Dear participants, dear speakers, hello everybody, and welcome to today's Rule of Law and Corporate Actors Talk. This is the first Rule of Law and Corporate Actors Talk, and we hope to have a series of the talks on sanctions regime, on human rights due diligence issues, and many other aspects. But today we will have very introductive talk about actually corporate power and how we can consider the corporate power and what is the role of the rule of law to restrict, if it's possible or not, the corporate power and all related issues. But first of all, one technical detail, the interpretation is available. You can use English or Ukrainian channel. And actually, we work with this team of interpreters since 2017, so they are already experts on business and human rights. Thank you very much to this team of interpreters. And we decided to hold all these events in a meeting format rather than a webinar format, since this format, in my feeling, gives a more sense of presence. So please feel free to communicate in the chat, to ask questions, to share your thoughts and reflections. And also we will have time to give the floor to our participants after having the round of discussion with our distinguished speakers. But more rights mean more responsibilities, so please keep your microphones muted when before you will be given the floor. And it's a great honor for me to introduce our speakers. And when I was preparing the introductive slides for today's talk, the first association that came to me was, the lamp as a symbol of light and the symbol of new ideas, and all these business and human rights names actually associate for me with new ideas. But then my second thought was that is this lamp actually a sustainable way of lighting? And all these people are for me not just drivers of new ideas, but drivers of responsible new ideas. So please welcome Professor Surya Deva, Special Rapporteur on the Right to Development, Professor at the Macquarie Law School and Director of the Center for Environmental Law at this university, and also since the 1st of May this year, Professor Surya Deva is also a Special Rapporteur on the Right to Development. A little bit later, Professor Karin Buhmann will join us, a professor at the Copenhagen Business School and also head of Center for Research Initiative, Center for Law, Sustainability and Justice at the University of Southern Denmark. Ioannis Kampourakis, sorry, I need to train my pronunciation, assistant professor in law and markets at Erasmus School of Law, Erasmus University, Rotterdam, and he has very interesting publications related private power of corporations and the rule of law. And David Birchall, who is a senior lecturer in law in London South Bank University, and he also has a lot of publications related to corporate power over human rights and related issues, and I strongly recommend to read it. And actually my first question to all our speakers actually, is corporate power a public power like state power is? What are commonalities and what is difference? Could we consider corporate power actually as public power? Because I know that, for example, Ioannis considers corporate power as private power. So please, who will start? Surya, could I ask you to start this discussion?
I'm happy to do that, and then colleagues can jump in. So I'll make 2 or 3 points. My first point is that the distinction between public and private power is often found problematic. So I think that is my starting point. So I think we should look at more in terms of power rather than whether it's a public power or private power, because sometimes this distinction is not helpful, and what may look like a private power could have some elements of public power and vice versa. And sometimes public power may become private, as a state is kind of outsourcing those functions, especially of public utilities. So is that a public power? Is that a private power? The state is doing it in terms of outsourcing. You can say this is public power. But if states are not controlling many dimensions of it, one may also argue about that it's a private power. And then how do we treat state-owned enterprises? State-owned enterprises are part of the government in a sense, but on the other sense, they are also private companies. So from my perspective, this distinction is something we should not pay too much attention, because we should look at the reality. What is the impact of power? So I would focus more on the impact of power, how that power center is impacting individuals and society. And let us say our concern often is human rights. So that will be my question. Now, in terms of the origin of the power, the corporate power is not derived like in a democratic setup, is derived by people. Of course, one may argue that corporations are incorporated and established under a law. The law is made by the state, and the state is representing people. So indirectly, you can say, oh, the corporate power is again coming from people. But it is very different from how we see public power of the state, of the government. So in terms of origin, it does not look like a typical public power, but in terms of its impact on public, how many people are impacted, it is definitely a very pervasive example of power. And my last point, Olena, is about legitimacy. I think you wanted us to respond to the question, should we confer legitimacy on the power, whether we call it private or public power of the companies? And my response is that they already have that legitimacy. The difficulty I find, though, is this, that there is a paradoxical distinction, that their powers are not acknowledged, or let us say their duties are not acknowledged, but their rights are acknowledged. And that creates a very paradoxical situation in which companies would claim that we don't have legally binding obligations under international law or international human rights law, but we have legally binding rights, and those rights create power. Let us say international economic law, investment law is a good example of that power. So companies have those powers, and they use rights as powers, but when it comes to the obligations, they would claim they don't have those powers. And I think that is definitely a problematic issue from my perspective. So I'll stop at this for now. Thank you very much.
Thank you. Thank you very much, Surya. Ioannis, please, what is your thinking about it?
Yeah, so thank you very much, Elena. First of all, thank you very much for inviting me. And yeah, this is a great initiative. So I would actually echo much of what Professor Deva said, which I suppose is a bit of a risk in this context, you know, that of course there's significant alignment. I do think that from a, let's say, sociological perspective, what fundamentally matters is the effects of power, as opposed to whether we categorize conceptually this power as public or private, which is why I think from a teleological perspective on the rule of law, what one should care about is really whether there is arbitrariness in the exercise of power, the effects it has upon the real concrete lives of people. And I think there's also some context where, again, in a more sociological sort of observation kind of frame, we see that, corporate power does assume pretty clear characteristics of functional sovereignty. For example, we could think about, how private legal ordering may, in instances of transnational governance, assume characteristics of bindingness, corporate codes, contractual governance of global value chains, and so on. So, essentially you have a company, a transnational company, being a regulator. Then in instances of platforms, very often we see the power, the assumed power, so to say, to resolve disputes extrajudicially. So that is also a power that is akin to some sort of functional sovereignty. Then, especially in instances of corporate frontiers, we see the provision of social services that extend beyond wages. So, you have provision of housing or healthcare, etc., as part of corporate social responsibility programs. And obviously, to some extent, one can say that this kind of functional sovereignty of private actors is not surprising, considering the lineage tracing back to colonial powers exercising their domination through corporate entities such as the Dutch or the British East India companies. So that I would say on a more from a more sociological perspective. From a more conceptual perspective, well, my general position is that corporate power, like you said in the introduction, corporate power is indeed a form of private power. So there is perhaps a value in drawing that distinction. But how should private power be understood? Private power should in itself be understood as a product of public power. So to a significant extent, I align with this legal realist position, so to say, that says that private power is a product of legal entitlements, of rules, of incorporation regimes, of, if you think about international law, intellectual property rights protection, investment protection, trade liberalization, and so on. So it's legal regimes that fundamentally provide the building blocks, the grounds for the emergence of private power. So in that sense, there is a distinction, but private power really has its source in public power, which means also that one should not take private power as a given. And that comes just one line on the point of legitimacy. I suppose we'll talk about it also later on. I do think that there is, behind new forms of corporate regulation, like human rights due diligence and so on, there is an implicit project of also legitimizing corporate power, in the sense that companies are tasked with addressing and mitigating the harmful effects they themselves cause. So they are asked to, the project of publicizing private actors, of incorporating in themselves rationalities beyond, profit maximization, beyond private rationalities. They should care about human rights, they should care about sustainability, social welfare, and so on. That is a project of some type of output, at least legitimacy. And the risk with that project general project of legitimization, even if it's successful, which of course can in itself be doubted, is that it precisely does not question these institutional foundations of private power. So it's like we take private power as a given, it's out there, we stay on the sociological observation, private power is there, we witness it, it's true, we observe it. And then what we try to do is to say, okay, how can we use this power now, harness this existing power to ameliorate the situation of global social welfare, when in fact we could, and in my opinion also should be, looking as to how we as sort of the creators of public power, the root of public power eventually being popular sovereignty, how we have created the kind of rules that have enabled this private power to exist in the first place. So corporate power is not an inevitable fact, and we shouldn't mask, let's say, the historicity of the arrangements that have made it the reality that it currently is.
Okay, thank you very much. And David, what is your opinion?
Hi, Elena. Thanks very much, and yeah, thanks very much for inviting me. So yeah, similar to Ioannis, I think I agree with lots of what both speakers have said so far. So as a starting point, I suppose, I would agree that thinking about a contrast between corporate power and or public power and private power, corporate power and state power, can be a bit of a false dichotomy, because the diversity of what companies do is so great. The diversity in terms of type of company, kind of authority and power they have is so great. And equally, diversity in terms of what states do, how states interact with corporations is so great. So I think for a starting point of private power and public power as two completely separate things is probably not the most useful way to think about it. And I think one of the problems in business human rights in general is there's just such a wide range of things corporations can do, types of power they might have, ways they can impact people, that it's quite hard to put it into a singular kind of framework, I think. State-owned enterprises as one example, as Surya said, and as Ioannis said, things like supplying on housing markets, healthcare, as well as the classic kind of human rights violations like modern slavery. So there's this really, really wide range of what corporations are able to do, how they're able to use their power to harm, sometimes to help people. And then into that, in this current moment, I think we're, again, as Ioannis said, we're coming into this time where corporations are expected to govern their supply chains, their partners, subsidiaries, which probably they should always have been governing, but they're expected now to be looking after their value chains, human rights due diligence, the idea that the lead corporation particularly make sure that its suppliers are respecting some basic human rights rules. And so this is legitimizing that private authority. It is placing some corporations in this governance position, saying they have obligations to govern, and that does then that does then create this question of, okay, so should they have this authority? How exactly should this authority be implemented? And therefore, also, what powers does that corporation need to actually be able to enact this authority? And I think this is one of the interesting questions about mandatory human rights due diligence laws. If they're going to come in, if like the EU law, the Corporate Sustainability Due Diligence Directive, CSDDD, is actually going to have sort of serious enforcement in it, then what kind of powers, what kind of rights are these large corporations going to have over their suppliers all over the world? How are they going to ensure that they can actually do human rights due diligence in the factories around the world that their products are being made at, and the mines and everything else? So it's a very interesting time with this question of like the relationship between the corporation and the state, I think. Yeah, and I can probably leave that there actually on that issue, because I think that we'll come to that later when we come on to the rule of law a bit more. But I think we are in this sort of slightly new era as business human rights continues to develop and becomes and mandatory rules become part of business human rights. This issue of authority and power between state and corporation is becoming quite blurred. And I think my final point here is just to kind of go back to the idea of public and private power. Like the traditional or the sort of classic definition of a state from Max Weber is, to paraphrase, the legitimate use of force within a territory, within a jurisdiction. And this is then vested in political authority, right? The state has the political authority, right to imprison, to kill, to use police and military and so on, and no private actor has that right, generally speaking, although obviously that's not always true. Whereas the corporation has economic power. It is only as powerful as it is rich, and it has no political basis for this power. This is an important distinction, but I think we are coming to a sort of a time where the jurisdiction of the state matters a little bit less, and economic power increasingly matters more and more, as although this maybe isn't going to be true forever, but borders have become more open, globalization has accelerated a lot. And so I think there is this change emerging from the state, the nation, being the absolute center of sort of political thinking, to global corporations, supply chains, that kind of thing, becoming more and more important. So it is an important governance question for sure.
Yes, thank you. Thank you very much to all of you. And actually, if we are going to use some classical terminology, could we say that the rule of law could be considered as a set of principles and rules and standards to restrict corporate power as well, not just state power? I don't know, Surya?
And if someone else wants to start, that's also fine. It need not be me starting. But before we jump into this question, if it is okay, I just want to briefly comment or build on what David was saying just now. And the point that I want to make is that the power of corporations is not merely economic, because they influence us all the time. So like, let us say advertisements, or the political power that they exert through, let us say, Facebook or other social media companies, right? Or the political donations that they make to parties in election processes. So what I want to highlight is that the power of corporations is multifaceted and it's very pervasive. They are definitely more powerful than many states, but even if they are not, let us say, more powerful than some states, they definitely are behaving like states. So they have, so instead of saying public versus private, I will argue they have state-like powers. So I feel more comfortable with that state-like powers that they enjoy. And in fact, I'm working on a paper in which I try to show that under international law, to establish that this is a state, there are those indicators, like you should have sovereignty, you should have territory, and all that. And I was trying to establish that can Facebook be regarded as state? Because it controls the web space, it controls that platform, So can we consider the idea of sovereignty and territory at this particular point of time very differently than how it was traditionally conceived under international law? I just wanted to make that observation, building on what David and Ioannis said.
Can I just jump in and ask a question here to Surya, if I may?
Yeah, please.
So I was wondering, does this mean that, in your opinion, we should also sort of like direct our energies as, let's say, activists or citizens of the world and so on, in the effort to, let's say, democratize the internal of the inner workings of the corporations? Or is it the struggle, let's say, to restrict the scope of power of corporations? So, because I'm saying this because I guess what is a logical extension of the thought that, okay, we can address Facebook as a state would be that then, okay, we need to actually struggle for the extensive democratization of Facebook. So Facebook should have internal monitoring mechanisms, like to some extent it tries to do with this, oversight board, or how it's called. And we should ask for processes of co-determination, perhaps, some shareholder democracy, I don't know, like shareholder activism, etc. So that's kind of one way where political action could be directed. Or, of course, we could say, well, actually, our effort is to restrict this, that we don't want, a Facebook to be state-like. So I find this to be a bit of a dilemma in how we address these transnational regimes from a more political perspective. So, yeah. I would be happy to hear your thoughts.
Thank you, Ioannis. And I'm sure David may have some thoughts on this as well, and other participants as well. But I also face a similar dilemma, and my response is two-pronged. my first response is that we need to recover the state. In the current neoliberal order, one difficulty that I see is that the state has consciously and in a systemic way has withdrawn itself and is giving the market too much role in terms of regulating corporate behavior and corporate power. So they expect investors and consumers and CSOs to play more role. That's what the whole ESG landscape is, for instance, or the reporting requirements of modern slavery legislation. So that is my struggle. So I would like state not to abandon its non-delegable duty, let us say, in relation to human rights, whether these are civil and political rights or socioeconomic rights. So I would say one prong of my thing is that we should try to recover the state. But my second prong is based on the assumption that this recovery of the state may not happen in the near future, or it may not happen at all in the next, let us say, 20 years or 30 years. So then what is my plan B? So my plan B is to argue that if that is not happening, then we should consider corporations as state-like entities, and then we should insist on the becoming more democratic. And I will argue that the boards of the companies, they should not be merely elected by the shareholders. They should be representative of non-shareholders as well. So that will be definitely my argument. And I think in some European countries, we of course have that possibility where there is a system of supervisory boards and all that. But that is more like an exception because typical boards of companies are representing shareholders and their interests. And I would very much like to challenge and question that, because corporations are having so much impact on what we do in our day-to-day lives. Like what we eat in our kitchens, what we study, what we read, how we travel, how we receive medical benefits, or anything for that matter. Everything is controlled by corporations. So they have so much power on our lives, but how much power we have on their decision-making processes. And that is my struggle. And that's where my argument is part of the second prong, that we should definitely create more democratic institutions, including corporations. And I welcome diverse views as well. I mean, so it's not necessary that all of us have to agree, and maybe even participants can jump in, because it would be good to have this kind of a dialogue. But back to you, Olena, so that you can manage the discussion. I see David has raised his hand.
Yeah. Please, David. Thank you, Surya.
Yeah, but of course, if anyone else from the discussion wants to jump in, then please just do that. But yeah, just to respond very briefly to that, because I mean, I completely agree with those comments from Surya and from Ioannis earlier. I mean, firstly, just to say that in response to the first comment, yeah, I completely agree that power is multifaceted. Just kind of making a point that corporations are going to, their wealth is going to determine how much they can do in the world, primarily. Just to say that was kind of what I meant there. But yeah, just to say on this point, I mean, I think it is a really this is such a fundamental question for the world at the moment. Are we going to try to contain corporations, or are we going to use this power they have to try to do good in some way, as human rights due diligence, I think, tries to do, using the power of large corporations to solve a few of the world's problems, or to try to solve a few of the world's problems. I completely agree that we need to recover the state as well. I think this is a really, really big issue of our time, and it's over-reliance on markets. Some states, not all, but some states seemingly very unwilling to do things, to plan, to have an industrial policy, to actually say, okay, these are our aims and this is what we're going to do to achieve them. Rather, it's a good starting question seems more like, what can our businesses do for us at the moment, and let's try to incentivize that a little bit. And I think this is a sort of ideological question. Some states are still very, very good at achieving things, about developing their country, that kind of thing. Many states, many liberal states, have are moving away from that or have moved away from really trying to do that. I do think on this, and also here the issue of, shareholder primacy, shareholder power, distribution to shareholders, all these kind of questions are very, very harmful for the world. But my only point here really was, I do think we are going to come to a time in the near future through climate change and refugees and migration caused by that and poverty caused by that, where I think we're going to, like the powerful nations and bodies like the UN are going to have to deal with this sort of head on. I think to me, I see it as a kind of drift at the moment. I think we've been, the liberal world, I mean, when I say we, has been drifting without really dealing with these issues that have been brought up by marketization, shareholder primacy, and so on. But I do think it's going to come to a head quite soon. Stagnation in the global north, climate change, migration, refugees. I think these kind of problems are going to mean a solution has to be found. And I think that perhaps the job of like business human rights and law and political economy type scholars is to try to imagine what these solutions might be when the time is right for them to actually be implemented.
Yes, thank you. And actually, the question about solutions, I think that probably is key question, because who or what should be the driver of such such solutions? I mean, actually, does it mean that our social expectations should be addressed to the states, and states should resolve these issues more strictly and have more power in economic sphere and restrict the corporations? Or do we expect from civil society that civil society will pay more attention to corporate power than they now pay? In particular, in my region, I could not say about all regions, but civil society watchdogs for the states because of our historical issues, but not over the corporations. So it's a good, I would say, it's a good purpose to restore state, but who should be this transformative driver? I'm waiting for hands. Yeah, Surya, please.
I can start if no, I don't see any other hands. So I would say that we need multiple sources to control the corporate power. And this is not unique to corporate power, I will say. Even the state power, we have created multiple pathways and processes and principles to control that, right? For instance, in a democratic setup, we talk about democracy, the process as the way to control corporate power. We also see the media as controlling the corporate power. We also see judiciary as controlling the corporate power. And of course, in a democratic setup, we're also talking about individuals. So what I'm trying to suggest here is that we need to use multiple tools to control the corporate power as well. So that would involve some very conscious investors and shareholders. That will definitely include consumers, but it will also try to harness the power of the state and regulators. And of course, there will be a role for the media and civil society and other actors as well. So I see a multi-pronged approach in terms of regulating corporate power and what they do in society. I don't think we can trust on any one pathway or one actor to control corporate power. We need multiple things. And I will argue that we need them together in a concerted way, rather than in a sequence one after another. That if one fails, then we use the second one. I'll suggest we need to employ everything together. I will stop at that, Elena. Thank you.
Yeah, thank you. But also, I see I have a concern that when we have the situation with poverty and with a very huge disbalance in society with social segregation, could we expect that actually shareholders could be so responsible to make responsible decision or not just go for, for economical solutions? So
Is that a question for me, Olen?
For all speakers, yeah.
Okay, I think okay, for all. Okay, so I see. I think Leonie wants to speak, so I'll give him.
Ioannis, please.
Yeah, but I didn't want to interrupt Surya. That maybe the thought was incomplete. I can just go right after. No, okay.
No, please go ahead. Please go ahead.
Okay, so yeah, I wanted to answer to this question. I guess already the previous question about ways to constrain, let's say, corporate power, by sort of breaking down what seemed to like resonate before, this notion that we need to recover the state. So I mean, of course, Surya talked about this multifaceted need to tools and so on, which strategically I agree, but I think in the core of this answer, and David said it before, Surya said it before, is this strategic, let's say, goal of recovering the state. And I also subscribe to this, but I think it also is important to sort of unpack this. What does it really mean to recover the state? And I think a useful analysis starts from what is really the main diagnosis that conditions the sort of business and human rights field to a significant extent. And there I see the notion of governance gaps. So, we have this idea that there is a disjunction between the power of corporations and the ability of society to constrain them. So there is like a permissive environment in Ragi's framework. There is a permissive environment in which corporations can engage in human rights violation and, sort of break down the global social fabric. And the market in itself has these expansionary tendencies that we can't really control. So my position and how I would talk about like recovering the state, and I'm not saying this is something totally new. Of course, other people have said it as well, but I think it also aligns well with the scholarship of law and political economy now, is that it is not really governance gaps that is really the issue, but it is actually precisely legality. So it's not the kind of lawlessness that in a way governance gaps alludes to, but it's more the actual legality, like I said in the beginning of our talk, that grounds corporate power, specific national and international legal rules. I mentioned some examples before on, like property rights, intellectual property rights, contractual regimes, investment protection, trade liberalization, etc., that it's an assemblage of institutions that largely, not exclusively, but to a significant extent, provides the ground for private power. So that means that a more, let's say, if we start from this kind of analytical premise that we're not talking about governance gaps, but we're talking really about a specific legality that conditions and creates corporate power, I think that leads to a kind of a critical perspective in business and human rights more broadly that is not then satisfied with, let's say, just better remedies or extending the rule of law, like you said before, in terms of like formal rules to just restrict corporate power that, again, take this existing corporate power as a fact. So it's not only about, new norms of transparency or accountability. Of course, all these things are good, but they are not sufficient, because that what we need, the step further, is the identification and the transformation of the legal structures that ground private power in the first place, and which then lead to predictable patterns of human rights violations. Of course, also, I mean, that's a bigger discussion. We can get into it later. We need to be aware of the limitations in this exercise. I also don't want to sort of sound like, everything is up for grabs and, we're living a completely like, I don't know, some sort of political voluntarism and legal constructivism. Everything is just legally created, so we can just easily just change property rights, change investment regimes, and blah, blah, bam, bam. Very quickly, we have achieved some sort of, global welfare. So it's obviously not that simply, because precisely this kind of legal structures are conditioned by social relations of production, by established power relations, so they're not easily amenable to change. But I think this kind of transformative impetus should be guiding exercises that want to fundamentally, well, not exactly restrict, but really practically transform corporate power. So I think that's what at least should be the guiding impetus when we talk about recovering the state, really tackling the building blocks, the sources of private power in the first place that are found to a significant extent within public power, within the state.
Mm-hmm. Thank you, Surya. Your reflections on it.
Thank you, Ioannis. And I think I tend to agree with his analysis and just build on and try to respond to the question he posed, that what does it really mean to recover the state? And I will mention for our consideration 4 quick elements. I did not think through this before, but it is just my quick reflection to after Ioannis posed this question. And I will add those 4 elements. First is the democratic deficits. One difficulty with the state that I see is that even in democratic countries, there are serious democratic deficits. They are not states and governments, they don't really represent us, the society, the citizens, or all people that are part of that state. So I think recovering state has to include this element of trying to overcome or at least minimize democratic deficits. The second element I will say is no outsourcing of the basic minimum in terms of human rights obligations, because I see plenty of outsourcing of those obligations, and David has written about it and others have written about it, about this commodification and commercialization of human rights. That is a major issue, and I think it is happening for many reasons, but one reason is that the state is outsourcing or taking hands-off approach, and or sometimes positively acting, conferring monopoly over private actors to deliver certain services, which are not merely services, which are essentially fundamental human rights under international law. So that is the second element of recovery. The third element is that the state has to behave as a neutral mediator. And often that is not happening because of the corporate lobbying and corporate capture of the state. So whenever there are disputes, let us say between the state and an individual, or between a company and an individual, or between 2 companies, I see that the states are not able to mediate or resolve those disputes in an objective manner, independent manner, and objective manner. That is part of the problem, because they are taking sides. And I think that becomes quite critical when in a situation where politicians may be the businessmen or businesswomen. So they are running businesses, and they're also sitting in the parliament. Or it could be a minister who is sitting in the government and he or she also has a big company. And I think in those situations, this neutral mediator role is absolutely crucial. And I don't see that happening at this particular point of time, because we have significant state business nexus of this nature that a state is not able to do that. So these 3 elements, I will say, are more relevant in the context of the national recovery of a state. But states also, in my view, have a collective goal in the world polity. And my 4th element, that's where is about the role of the state when they are negotiating at the multilateral setting. And I will highlight here the fair distribution. Whether we are dealing with issues about economic inequalities, not only within countries, but among countries, that is a major issue. And that is where states should come together as part of that recovery, and they have to fix and address those issues. Same applies to climate change. Now, I was in Bangkok speaking at this conference here, and the expectation now is that Asia should lead the climate change action, because Asia is contributing to more than 50% of global gas house emissions. And I tend to agree with that, but I also question it, that who has contributed this? Consumers in Europe are benefiting from the pollution of Asia. Asia is polluted because the global north has pushed all the manufacturing to the global south. And that is where the developed countries, the global north, and the companies who have benefited and made billions of dollars in profit, now they have to, as part of their responsibility, come forward and support developing countries in dealing with climate finance and just transition and providing green technologies. I will stop at that for now. Thank you. That's a very fascinating webinar, and thank you very much for bringing us together. We should thank you.
Yeah, thank you, Surya. And yeah, David, please.
Thanks very much. Yes, I mean, a first thing I'll say in, well, a little bit of response to both there, I think is, I think a fundamental thing here, if we're talking about controlling corporations, controlling corporate power, establishing some kind of rule of law over corporations, I think a fundamental thing is for states to accept the authority they have for human rights within their jurisdiction. I think this is the prefigurative necessary thing that has to happen before a lot of these problems can be dealt with, particularly to do with markets, but also other issues of corporate power. I think the state needs to accept, okay, there is a right to healthcare, a right to education, a right to housing in our state, and that is our responsibility, our obligation. We have to achieve that. We have to realize that right. And it is our fault if it's not being realized. I think that kind of idea is something that's kind of been lost over 40 years of marketization. This idea that actually the state is responsible for it fundamentally. So I think that as a sort of normative framework for states to work in is fundamental. The other thing I was going to say, in response to Ioannis primarily, I suppose, talking about governance gaps. So, I mean, completely agree with you on the constitutive law issue. I mean, I think Ruggi's idea of governance gaps has a certain logic to it. To my mind, he's seeing that there are countries and areas and regions where labor rights, for example, are well protected, and corporations can't really get away with violating them and don't try too much to violate them. And there are other regions where the laws are just not being enforced, and corporations have made a very rational choice to place their labor in those places where there are no labor laws or weak labor laws, and therefore you can have people working very long hours for very low pay. And that's definitely one important type of problem, and not just labor, of course, but environment and other things. And Ruggie sort of kind of focuses on that. But as Ioannis said, this idea of legality, of constitutive laws shaping what corporations do is so important. And this comes to the rule of law issue really, really closely, I think, because to my mind, the closest thing there is currently to a rule of law for corporations is company law, corporate law. This defines what a corporation is. You've got directors' duties, you've got articles of association, at least in the UK, defines how you start a corporation, the different types of corporation, what corporation can do, all that kind of thing, as well as insolvency law and so on. All that. So there's this very complex legal framework shaping what corporations can do, and also incentivizing specific behaviors from corporations. So these laws can be amended if states want, and the EU CSDD is going to, or well, potentially is going to add a new director's duty or change director's duty so that directors are legally responsible for conducting human rights due diligence, although exactly what that will look like, I think, is not quite determined yet. But there are these laws here that shape what corporations do, and in the UK, and I'm sure many other countries, they've changed quite radically in the last 40, 50 years, with massive effects on distribution of wealth, on what corporations do, what shareholders can do, shareholder power, all these things. So, just to say that this is going to be a fundamental thing. The corporations are creatures of law, they're constituted by law. Those laws can and do change frequently. And this is definitely a key thing we should be looking at when asking these questions about corporate incentives and looking for better behaved corporations.
Yes, thank you. Yeah, and I also see that Ioannis has reflections on it. Yeah, please.
Just a very brief point, and I don't want to move the discussion to something more specific, but just in response to something David said, because at least in my mind, the whole diagnosis of governance gaps is important in the sense that a lot hinges on that. Like, what do we really find to be really the root of the problem, so to say? And that, of course, depending on what we find, that conditions our responses. So that's why I consider this to be like an important part, at least, of the whole conceptual apparatus. And so I actually, on a certain level, I do concede the point that, of course, we have to take into consideration the variety of different, the difference of regions, and that there might be areas, like David said, where there is lack of labor law, simple as that, and therefore it is really a governance gap. So there is an area of lawlessness. So on one hand, I see it, but I would also like to problematize it. But we don't need to get further into it if you don't want to. But I would like to problematize it in the sense that, being able to push manufacturing offshore is dependent on certain legal conditions. So the fact that you would have, for example, no capital controls and capital mobility, liberalization of trade, that means that you can more easily and inexpensively move parts and commerce and so on and products around the world, etc., are conditions for moving already to an area, legal, let's say, prior legal requirements for being able to move production in an area where there is labor under enforcement. So I would just I would just problematize the notion that even there, there are some international legal rules or national legal rules from, capital exporting countries, essentially, that create the institutional environment that eventually enables, the human rights predicament in the first place, sort of makes it happen.
Yeah. Please, David. Yeah, please.
Yeah, I just respond super briefly. I 100% agree with that. And I think to my mind, Rugg's idea was focused on there being a lack of enforcement of laws. When he says governance gaps, that's what he's talking about, right? Completely agree with Ioannis that it's a lot more complicated than that. But now I suppose this comes back again to just the variety and complexity of these issues, and why, again, something Ruggie said, that regarding a binding treaty, that there's so much diversity of problem and type of problem in business and human rights, that trying to have one treaty to solve all the issues, regulate all the companies, is not possible. And I think this is part of this complexity, right? If you look at it from the perspective of workers in Bangladesh or the Democratic Republic of Congo suffering their specific problems, you're going to get this governance gap framework, right? If you look at it from how big multinationals in Europe and the US are able to use that labor, you're going to have an entirely different view of it. And so there is going to be a lot of dispute and debate around what the best solution is and how those solutions can be implemented.
Yeah, and actually, to be honest, I think that the business and human rights agenda was built from the very beginning just because the enablers of states to ensure the protection of human rights, and actually that's why, because of this gap, we have so strong expectations that corporates will be more responsible when we have this gap because of the lack of state ability to protect human rights. So probably if we will have restored state, we will not need so much business and human rights agenda. I don't know, because just the state will implement their functions. And that's why actually as business and human rights agenda is built also in this idea of social expectations, I actually see very huge concern about business and human rights framework in the regions which has this history of very strong state power already. And that's why when we start this conversation in post-Soviet countries, that actually we need to make corporations more responsible, and we need to pay attention of states also to enforce this framework in these countries. In many cases, it takes as a risk to be back in history when the state played the leading role in economics. So how to balance, these risks that we will have too much state power with actually our intention to have free market, because our region is still building fair free market, if it could be fair. So there is a concern, and the question is, what can we do with the law? What is the role of law? And that's why I'm back to one question. Do we consider the rule of law still, no, you already said a lot about it, as a state-centric concept? Should we expect that actually it should be the leading role of the state, or and actually Surya already said that it should be something multi-roles, multi-actors, but what is the role of self-regulation of companies themselves? Should we expect from them that they will cooperate to each other to set some rules? Surya, please.
Thank you for the question, and I would say two points here. One about self-regulation, but I also want to highlight the other element about the state-based regulation, the role of law, and all that concepts. So let me start with the self-regulation. I believe self-regulation has a role to play in society, not just for companies, but for all of us. Like all the human beings, many of us at least, we self-regulate ourselves. So self-regulation definitely has a role to play in society. We cannot expect either state or the market forces to regulate behavior of actors in society. But for me, the crucial thing is that whether this self-regulation is completely self, or it has some non-self element, if I could use that word, non-self. I know it's not a dictionary word. What I mean by that? I mean by this is that there is some external control over the self-regulation. So let us say a company has adopted a code of conduct. That is self-regulation. But what is the role of trade unions and society, civil society organizations, and the media in that self-regulation of that code of conduct in terms of monitoring and enforcement? So to make self-regulation effective, we need to bring that non-self element. Then it becomes, self-regulation becomes more effective. The other dimension of self-regulation, in my view, is that the state has a role to play by creating incentives and disincentives for self-regulation. So if some companies are not behaving well because of self-regulation, the consequences should be very harsh and swift, so that other good companies, it creates a positive signal that, look, self-regulation or lack of it does not pay. And if you self-regulate, there should be reward. So I will suggest there are those elements of self-regulation. Now, in terms of rule of law, the question that you had posed, Olena, I think it will be fair to say, at least from my perspective, that many of these public law concepts, whether it's rule of law or whether it's separation of powers, or we're talking about international law or international human rights law, traditionally, they were designed and developed keeping states in mind. Now, can we be, lawyers are creative, so can the lawyers and the legal rules be creative and be adapted to this new normal in which we have this new center of power, which is not a state, and I will hesitate to call it merely private power. So it's like a state-like power. So how separation of powers, for instance, can be applied in the context of corporations, right? Because that is a key tool, separation of powers, that we use in relation to state power. Same logic can be applied in the context of rule of law and other concepts. And I think that's where, if I have to take examples of constitutional law, because one of the main purposes of constitutional law is to control public power, state power. So how could we harness the potential of constitutional law to control corporations? And I think one possibility here is the horizontal application of fundamental rights. So if we can extend the fundamental rights under the Constitution against corporations, that is definitely one possibility. Similar logic can be applied in the context of international human rights law. So we often do not talk about, of course, there are some exceptions, and I think even Nadia has, I think, written about it, direct obligations on corporations, because normally we think of indirect obligations against corporations. But I personally believe that we have reached a stage where we should not pretend that companies cannot and should not have direct obligations under international law. Let us look at Wagner, for instance. So it's not merely about human rights. It's much more complex, you know. So a company which has a monopoly to supply, let us say, health benefits or vaccine situation, right? Who were manufacturing vaccines? Not governments. These were companies. Or we have a company like in a conflict situation like the Wagner Group. Or we have a company, let us say, Facebook or whatever, who of a tremendous size and kind of complete monopoly, and they can even suspend a president from the platform. Of course, I have no sympathy for that president, but the point is, as a matter of principle, they have that power that they can exclude someone, right? So we definitely need to recalibrate state-centric norms of national law as well as international law. I will stop at that. Thank you.
Thank you, Surya. David, please.
Yeah, thanks very much, Elena. Yeah, I just to jump in with a tiny, with sort of an aside, let's say, a slightly related point. So yeah, I'm not 100% sure how like rule of law, separation of powers, how they tie in with corporate power regulation, as we kind of said before. But just to make the one point that I think the essence of liberal governance is, and rule of law, constitutional law, separation of powers, is about liberal rights-based freedom. So quite minimal, basic, often procedural type standards, which states are obligated to uphold, are bound by, but with the key purpose of then allowing the state to be free within that. So you set these basic standards. These are the few things you're not allowed to do or that you have to do, that there will be oversight of, and then the state has freedom, right? I think this is the essence of liberalism. So like life, liberty, property in Locke's formulation. Okay, so these are the rights people have: the right to life, the right to liberty, the right to property. State becomes constitutionally obligated to respect those. And then both the state and the individual is free, more or less, apart from that. And I do think there is a key similarity in what we're seeing with business human rights here. Again, business human rights is primarily predicated on corporate freedom still. So it's setting a minimal, you could say, constitutional or Bill of Rights kind of framework that corporations have to respect. And in so doing, it's also saying you then have freedom once you're respecting them. So to take mandatory human rights due diligence as the key legal development in 2023, it's saying there are these quite minimal and quite specific things that human rights that you have to respect. This list of things you have to do. Some rights are excluded from it. And once you do that, you then have a more legitimized form of freedom. So things like, well, any kind of egalitarian distribution is off the table. There's no rules on how many homes they can own, how many hospitals they can own, how much they can buy up. There's nothing like that. All that is off the table. All that is in the realm of corporate freedom, capitalist freedom. You're allowed to do that. So, but we're going to create this basic rights-based framework, very similar, very different in form, very similar perhaps in ideology to the kind of Bill of Rights that many states have. So I would say there is that similarity between current business human rights and the sort of ethos of the rule of law in liberal governance.
Thank you, David, for this point. Yeah, and actually, probably, if we don't have raised hands from our participants, yeah, probably the last question for our speakers. If we are talking about this shift to new business model or new business strategy, which will be more democratized and which will also be based on this requirement or expectation of real participation of rights holders, on other stakeholders, and which will be more human rights oriented, or whatever how we call it, actually, do all parts of the world have equal chances to be part of this transition to this new business model? Ioannis, please.
Thank you, Elena. So, yeah, actually, I wanted to, so this ties in with what I wanted to say, because I wanted to respond also to the question before, and in a way also respond mostly, I think, to Surya's comments about self-regulation. So I think this is indeed sort of the promise of a transnational rule of law, that we have different systems that sort of, exert learning pressures on one another, and eventually there might be in a process. So if we would like, this sort of this theoretical model of global law without a state, in like Teubner's way, there's learning pressures exerted from one system to another, and eventually they're in a process of self-constitutionalization, because, for example, companies might respond to pressure from shareholders, media, courts, and so on, and as a result to an increasingly demanding market, to certification, which demands certifications and so on, and therefore companies might be in a process of self-constitutionalization, or limiting themselves, essentially, put it more simply, like a self-regulation. So but a self-regulation in the sense that they incorporate logics or rationalities that are beyond traditionally understood private logic. So a company, when we say self-regulation in the sense of a transnational rule of law, would mean that a company would include within its own ambit logics that go beyond, let's say, profit maximization, but they are suddenly, also interested in, affecting, protection of human rights, sustainability, environmental protection, and so on. And that is, let's say, the promise of this transnational rule of law. And at least in this theoretical framework of reflexive law and in polycentric governance and so on, the idea is that this really stems from the notion that the economy has its own logic, and the best way for it to limit itself is from within. Because if we try to impose things, companies will always have ways to evade regulation. They will always be able to avoid, to have a more sophisticated plan of acting fast and so on, and they will never really internalize this. They will do like some compliance that is just for tick boxing exercise, but not real compliance. So eventually top-down regulation is kind of bound to fail or to be like very partially successful. So the biggest, like the highest promise in this global law without state kind of idea is that, well, eventually private actors incorporate, really like make it part of their corporate culture and their identity and so on, and their corporate governance framework, this notion that there is other obligations like human rights and so on. I think that this is sort of what I would say the promise at its best, so to say, of self-regulation and so on. And I agree with Surya that, of course, this has to be somehow also controlled by the state, and the state has, in a way, a role there in facilitating this and so on, also in Tobin's framework, in human rights diligence, of course, in Ruggie, who also draws from this conceptual apparatus and so on. I think, though, there is two fundamental problems with these two critiques, and I think this also speaks to your last question now, Olena. I think it has to do, one fundamental critique, I mean, I don't think this is something new, but putting it on the table, there is a fundamental critique that stems from the requirements of the democratic principle, and specifically input legitimacy. So I think there is, I think the democratic principle in its basic terms requires that we all see ourselves as the authors of our own laws. So even if we, let's say, imagine a regime that is very beneficial for some, like, let's say, for workers in global value chains, if they haven't participated in the making of such a regime in the first place, then arguably this regime doesn't benefit from input legitimacy. The ones who are benefiting from the law, let's say, have not really participated in its making. We could think about ways of addressing this to some extent. Perhaps that's implicit in your question. If, for example, trade unions would participate more actively in, the making of human rights due diligence plans, and trade unions not only, and other stakeholders, communities, and so on, not only trade unions of, the global north side of the thing, but, let's say trade union of the factory in Bangladesh, wherever, then they are able to participate in the making of the human rights diligence plans and identify, the risks and the ways to mitigate them and so on. That would be a way to address what I'm saying now as a lack of input legitimacy, potentially. And the second critique, but I think a lot of debate is there, to what extent, human rights due diligence, for example, will be subject to democratic input, to public control, and so on. And the second point of critique, also not surprising, is that this transnational rule of law kind of idea with self-regulation and so on eventually really depends on market pressures and civil society pressures and market pressures. And it, in a way, institutionalizes even those market pressures in a way that, of course, also institutionalize somehow the inequality of social power that is inherent in the market. So, of course, obviously, not all actors, and especially, like you said in your question, there's a significant difference between, global north and global south actors as to how they can, through, let's say, their market activity, through, what they pay and so on, can really influence eventually, the self-regulatory process. You can't, I think it's a bit of a reach to expect that, increasingly the global society will demand, fair trade products, and therefore, there will be more certification and companies will be forced to incorporate that, and that will lead to better production standards overall. Even if this were to be the case, it really depends upon a small minority. So it comes again to this input legitimacy thing somehow. It really depends on those who have the market power to exert this kind of influence, and not to those that don't. So I think these are two fundamental problems from this idea from an over-reliance on self-regulation and transnational rule of law. Of course, keeping in mind, and with a small asterisk, that of course self-regulation can be subsidiary in certain parts and so on. But I think there are these two significant problems.
Thank you very much, Ioannis. And I see Surya raised hand, and we welcome very much Karin Buhmann. She joined us. Thank you very much, Karin. And then I will give the floor to Karin. So Surya, please.
Thanks. I just wanted to say that I'm about to log off now. But I wanted to make one observation before I log off. And that observation is that many of these regulatory ideas, polycentric governance or the whole idea of Pillar 2, I often feel they are based on certain assumptions which do not reflect or represent the global South realities. I think we should be aware of that. For instance, if we look at Pillar 1 also, we are expecting the state where the conflict is unfolding to do more to ensure that the companies respect human rights. Is that real? Is that real even in the global North? Forget about the global South. Pillar 2, can the HRDD steps which are laid down expressly by the Pillar 2, can they ever be complied by the informal economy actors in the global South? Let us say a tea shop. Because it says, oh, the human rights policy must be adopted and adopted at the highest level, and you put it on your website and all that. This tea shop has only one person. There is no highest authority, there is no website, there's nothing. And what kind of due diligence they do in terms of sugar and milk they buy. So my frustration is that many of the regulatory ideas in the BHR space are not alive to the ground realities, especially in the global South. And that also is my reflection on the current directive negotiation, because that will have extraterritorial effect on the supply chains in the global South as well. But to what extent are we talking to the global South before we are enacting that directive? Will it encourage tick box compliance, or will it change the life of the workers in the global South? And when I go to South Asia, East Asia, all the stakeholders are talking about, is this neo-colonial that European Union is imposing this directive on us? So the mandatory idea is good, but are we getting it right? And I wish I could stay until the end, but I need to log off with these some random thoughts. But thank you very much for organizing this and for having this discussion, everyone. Take care and hope to see you somewhere.
Yeah, thank you. Thank you very much, Surya, for that you joined us. It was great to have you during this event. And yeah, Professor Karin Buhmann, please, the floor is yours. And you know the whole list of questions that we discussed, and we would be happy to know your thoughts about these questions, please.
Thank you very much, Alina, and apologies for joining late. As Alina knows, I was in another meeting, and then once I actually tried to get in, my computer rebooted and I couldn't get into the internet, and Zoom had to download again, whatever. So you all know. So thank you for raising these interesting questions. And I think, in a way, I'd like to pick up on where Surya left, because I have to say, as a lawyer, I often present myself as maybe the skeptical lawyer. I think law as, we need to distinguish between law, the individual laws and statutes, and law as like a science and a societal practice or institution. I often, when I talk to students, I have many students who are not law students, and I often, in order to get them to grasp sort of the strength and what we can really do with law, and that law is not just black letter law and enforcement, it's a lot of other things also if we use it intelligently. I say that I conceive of law as a science on the institutionalization of norms of conduct. But so given that, I think that right now, when we look at what the EU is doing with this like tsunami of legislation on corporate sustainability, I really recognize the commitment to try to prevent harm that goes into this. But I'm also a little bit worried that that by, whenever you transform something into law, there's a real big risk that what you get is a compliance tick box exercise. So what we've seen in the past, for example, in the NFRD, if we look at the preamble of the NFRD, there's lots of really interesting thoughts on how non-financial reporting can help companies transform and become more sustainable. But once we move into the operative provisions, and that's what the lawyers will look at and check whether their colleagues in the company actually comply with, because that's also what the auditors will look at. And then, all of these ideas that we had, the policy ideas, they're not there, right? For the CSRD, there is an effort to try to address some of these problems, but I think we're missing a fundamental discussion, which is really how well is the conventional way we think about law and the way we use legal institutions suited for addressing the harmful impacts of transnational corporations, or any corporation when they act transnationally. And I think they know what one of the points that Surya brought up was really that, well, is this just really too, I would like to say, is it too Eurocentric, right? And then if it's Eurocentric, it can also be conceived of as neocolonialism, whatever. There is no doubt about it. Right now, what Europe is doing is actually telling Europe-based companies to act the way that that companies can perhaps more easily act within Europe, because Europe has a different economic, institutional setup than many other countries. So the EU is, and I recognize the need and the objective, but I also recognize that there can be hesitations, right? Because EU is actually regulating the conduct of non-EU companies in the supply chains outside of the European Union's jurisdiction, through requiring companies to undertake specific forms of action. And I think there is a big issue here. There's a big democratic issue in the fact that the EU legislators are actually regulating the way that workers in the supply chain will be, requirements that will be made on those also with their employers. And I still recognize the need to do it. I recognize there are lots of governance gaps. I recognize that companies have in the past also been benefiting from these governance gaps in order to reap profits. And in the process, there's been a lot of human suffering and harm and environmental problems. We have climate problems. So I recognize the problem. But I think going back to the key questions that you asked, Olena, is that because this entire situation of regulating transnational business and their value chains is so fundamentally unfit for regulation through the existing institutions and modalities we have, within the way international law is set up, within the way that legal systems are set up to basically address issues within their jurisdictions. And because of these huge differences between countries in the global north and the global south, that are also one of the reasons why we have global value chains. And I think all of those challenges, they just don't go together to really, then I think they're all too limited to address the real problem. So I think in a way, we need to turn the issue on its head and say, what do we need to deal with these problems? Do we need to come up with new concepts? How we've seen for decades that the conventional concepts, for example, thinking about the rule of law, it hasn't been up to the task. Because the rule of law, the conventional thinking, the thinking of state duties, even the entire Pillar 1. I mean, what Pillar 1 says is basically what was already there, right? Pillar 1 in the UN framework and guiding principles basically just remind states of what they already existing obligations, right? But that conventional international human rights regime definitely wasn't able to deal with the problem. The conventional way of thinking about the rule of law definitely hasn't been able to deal with the problem. By contrast, we've seen many countries saying, well, we're actually not going to do too much about regulating the way that foreign businesses operate and their conditions, because it brings in nice capital, nice investments when we want that. So I think in a way, what I would like to sort of maybe invite us all to think about towards the end of this seminar is what we can get out of actually turning the existing way of conceiving issues on their head somehow, or maybe sideward ways or something else, because the existing concepts and institutions and way of regulation have definitely not been up to the task. And I think there is a really huge issue that Surya reminded us, is that it is very, very dangerous to see things only of the perspective of, say, industrialized countries or the high north, that we really need. And regulators need to do this, and scientists need to do this, and civil society organizations, which already do it a lot, but probably need to do it even more, to need to put ourselves in the shoes of those for whom this is really about. So there's a big global south issue to this also, a big issue of really making meaningful stakeholder engagement truly meaningful, also in processes to develop corporate sustainability regulation. And then of course there's so sort of this sort of, wouldn't say a new issue, but this issue that has really taken on say a new fire, also confronting the way that global north countries look at global value change, which is the issue of responsible disengagement that in recent years has become even more pressing, and the war in Ukraine shows. And again, this is just a global north a global south issue, but it's also it can also be regional issues that are again confronting the ways that the international legal system works. It's just not up to the task for these very complex issues. That would be my message. So thank you very much, Olena, for the invitation.
Thank you very much. We still have 4 minutes, and if we have some reflections, some questions, some, I don't know, critiques, please feel free to share with us. And I also see the comment in the chat about that actually constitutions, many national constitutions have endorsed the concept of social function of property, including Western liberal democracies, which means obligations both for states and as well as private actors. The latter are obliged to use the property in a way that does not contradict general interests, also called common good. The principle is there. The problem is its endorsement. But I also think that the problem is how we interpret this principle, because the interpretation could be very limited and could be very oriented again on state-centric regulation. So the state should say how we can use our property and how we cannot, but all other things could be done by owner freely. So it's also about type of thinking in the society and understanding of law and common good and so on. But yeah, probably the final round of thoughts, Ioannis, David, Karin. I see Nadia Bernas is with us, so probably Nadia, you can share your reflections. Yeah, please.
I can just very quickly jump in. Thanks very much for organizing this, Elena. It's been really, really interesting, I think. Yeah, I mean, I won't repeat what I've said previously. Just as a reply to Karin slightly, I mean, I think I'm really interested in these mandatory human rights due diligence laws, because, I mean, it seems maybe this is similar to what you were saying, but it seems like they're starting from the method and then just trying to enforce that on European companies and therefore around the world. I have a big problem with how mandatory human rights due diligence is going to play out in practice. I mean, I completely agree on the one side with the neo-colonial element, the lack of input legitimacy. And then on the other side of it, I think the only way it will actually work to solve outcome-based problems, to reduce modern slavery and any other human rights violation, is if the corporations are actually able to behave like a powerful colonial type actor, because they need to have at least the ability to see what's going on in their suppliers and anyone else. And probably to change that, at least to change supplier. But they seem to need quite a lot of power, They seem to need to have quite a lot of power that maybe they don't really have right now. So is it actually going to, in a way, make the problem of corporate power even worse? Is it going to kind of put these corporations in this governing framework? And I think the one case that's currently come to a conclusion under the French duty of vigilance law, to me, is quite instructive. What the judge said in that case about how the judge was saying, I'm finding this case difficult because there's a lack of definition in here. I don't know how much due diligence these companies are meant to take. And I think this kind of, I can well see mandatory human rights due diligence ending up in this kind of gray area where most cases just can't really be dealt with properly in the courts, because there's going to be a lack of clarity around exactly what corporations are going to do. There's going to be lots of loopholes for the corporations. And in the end, it's not really going to enforce kind of neo-colonial power, and it's not really going to help rights holders. It's just going to be a kind of muddled policy that doesn't change a huge amount. I could see that playing out, but probably will provide lots of work for lawyers and consultants and things like that. So yeah, I think as we're low on time, I think I can leave it there, and I see Nadia's hand is up. So thanks again, Elena, and thanks to everyone else.
Thank you so much, David. Nadia, please, we are happy to see you with us.
Thank you, and thank you so much for organizing. I've mostly been listening, and I know this is now the end, but since you asked me, I'll say something. I think what we see in this due diligence legislation, we see it already with the French law, and maybe we'll see it with the European one, if and when it ever comes into force, that there's a whole lot of assumptions around these legislations. The assumption that everybody, all the actors will do what they have to do. The assumption that companies want and care about respecting human rights and the environment, and that all is needed is an encouragement for them to do so. And that if somehow each company does that individually, that will somehow transform human rights and environmental protection, especially in global South countries. But there are so many assumptions in that. It's based on the premise that there is this willingness to change, that somehow these actors are equal, and we know they're not. We've been talking about corporate power for the whole state-like power for the whole of this talk. It's completely unrealistic to think that this is the kind of legislation that will change things. And I think the best example of that is that France has had it for 6 years, and it's not like, capitalism ended or was turned its head, or somehow French companies have transformed. They have not. I mean, we can already see that. In other words, the change has been minimal. And of course, there has been some debates about the French law and the meaning of some words, etc. But at the end of the day, what we see is that it's been just scratching the surface of the problems. And so I've said that before, but I think if we continue investing only in due diligence in terms of advocacy, we're just missing the point. And that's not to say it shouldn't happen, but it is problematic, and I don't think it will really address the issues we talked about today, particularly around company law and how this continues to dominate basically how companies behave. So yeah, these are my thoughts.
Yeah, thank you. Yeah, thank you very much. Ioannis, Karin, some final thoughts, and we should finish today.
No, I won't add anything more substantive to the discussion, Elena, just to say thank you very much for organizing this. It was a pleasure for me to participate. I think lots of food for thought, and obviously I can see how the discussion ends up revolving around the current development on, human rights diligence. And of course, this is really at the forefront. And I had the feeling that we all sort of share the same kind of skepticism about it. So so the question, I guess, becomes how to move forward in the whole business and human rights discussion, considering this development. So again, yes, many thanks for the invitation, and it was really great being here.
Yeah, it was great pleasure to meet with you for the first time, and I hope that we will continue our communication. And we have the idea to develop the proposal of the book on the rule of law in corporate actors. So let's think about it as well. Karin, please, just a very final words.
Thank you very much, Olena. Well, I'm sorry I missed the first part of this very interesting discussion. So I'd also just like to thank you for convening the seminar series and also sparking us into some debate that I think are needed to advance the subject rather than just sort of standing on the spot. That I really like the questions that you ask and how it can get us to think about how we can continue to ask the difficult questions and hopefully through that way also contribute to moving the entire field of business and human rights and responsible business conduct.
Thank you
very much, Olena.
This is the perfect final word. So thank you very much for joining us. And the record of this meeting will be available on the page that I shared in the chat. Thank you again. I actually had the great pleasure to have all our speakers today. So thank you, and see you soon. We will have the next talk on the 13th of October with Nadia Bernas as well. So, see you there. Thank you. Bye.